I gotta get this down to the science here eventually, Bill.
I know. I'm still working on our timing, Nick, but if I may,
Yep.
please. From IBM TV, International Broadcast Media, this is The Lawyer's Den, a special report from American politics. This unique broadcast brings you in-depth discussions with our American legal scholars and some international ones as well to discuss current issues. I'm Bill Tresvant, and along with my esteemed colleague, from the South, Nick Palavita. We're your co-hosts. So, Nick, will you please do the honors of introducing our guests?
Yes, I will. And from our panelists from the city of Salt Lake, or otherwise known as Salt Lake City, a attorney who has many years of practice, licensed before the Supreme Court, got me licensed before the Supreme Court. And I'd like everybody to give a warm welcome to Jeff Teichert, who is one of the top attorneys and constitutional law scholars. But speaking of constitutional law scholar, we can also go down into the heart of Georgia and at Georgia College, Midgeville, which I've been to, believe it or not, because I used to live in Atlanta. So I'm sort of familiar with it. We have a professor of law, and we have Adam Lampanero. Adam, welcome to the show again.
Thank you.
We're doing great. We got a lot of good stuff coming today in the den. And one of the best things to come in the den in a long time is from Miami, Florida, by way of Lithuania. Gidri, where are you? Welcome to the show.
Good afternoon.
Yeah. You know, she adds a good flavor to the den, okay? Because the thing is, otherwise the den is like, you know, all these guys, yuck. But glad to have you here. And also, she's another J.D. Ellum attorney, like everybody on the panel except for Bill. So, not that I would remind you, but anyway, I think I would. So, but Bill is basically the primary host. He's the leader of the den, so the alpha dog. So he's got all the questions and all the things that we're going to cover today at the den. And we may have some more people joining us, so
Nick,
I'll bring them in if they come in.
I don't know why you're being so nice about it. You're gleeful that the United States government is attempting to bust up Google, your arch enemy. And nevertheless, you know I'm only here because it is beneath your talent collectively to even form questions because you're all LLMs. So with that in mind, we have an interesting evening tonight. There are a couple of issues on the table. One of the issues that I think we'd like to discuss is the potential impact of Chief Justice Roberts shifting his vote from the right to the left. We've already seen one example that has resulted in a 4-4 Supreme Court tie. And Adam shortly will explain to us what happens when you have a 4-4 tie, much to the chagrin of Republicans.
Is there a tiebreaker, or do you roll dice at the end, or what happens? That's pretty interesting. 4-4 tie. Do you go to tiebreaker in the last couple seconds, or what do you do here?
Wait. Do we play rocks, paper, scissors?
Paper, scissors. Decision made. That's how decisions are made in the United States for our international viewers. Rock, paper, scissors. Decision made.
Oh, okay. Well,
maybe you can give us some insight on these 4-4 ties. What do they do, Adam?
Well, when it's a 4-4 tie, it essentially leaves in place the lower court's holding. And so it operates as a de facto affirmance of the lower court's holding. That's why it's so important to have that ninth justice, and look forward to welcoming Amy Coney Barrett to the Supreme Court very soon.
Well, listen, first let me get through the first part of the agenda, and then we can scramble it all up, counselor, if you don't mind. I mean, if you don't mind being called counselor at some point in time, you know, if you don't make it as a professor, you might have to hustle with us just for dollars. Nevertheless, there is the other issue of the still immigration cases. There's another case out there in which immigrants, well, the Trump administration is currently attempting to block illegal immigrants from receiving representation. And I know our esteemed colleague from Miami might have something to say about that. And then we have the ever-present day two, because it's just starting, USA versus Google. And as the impact of this court filing begins to cascade through our society, people are waking up and asking a lot of questions that we began to ask yesterday, like, how far will this go? Does this have legs, not just with the current administration, but any future administration, regardless of political party? And I know that that is a subject very close to my colleague and co-host Nick's heart. And of course, to make sure that we have a libertarian point of view, we have our go-to man, Jeff, who I suspect may in fact occupy the role this evening of Chief Justice Roberts. So
He looks like a Chief Justice, so
he certainly does. And of course, he did run for a judicial office in Washington State in 2006. So I think he's got a leg up on all the LLMs. But what do I know? So, let's go through this with a cert vote. And I'd like to incorporate this. It'll take 3 votes to pick the first subject. Do I have 3 votes, 3 hands to support a discussion of the immigration case? 1. Okay, so I see 2. Do I have 3 votes to talk about Google versus the United States? Okay, well, we got we have 1 Chicago vote and then 1 vote in. All right, then do I see any votes whatsoever to talk about Chief Justice Roberts' leftist shift?
Oh, wow.
Okay, that's it. By a 4-0, it's granted cert. So let us begin with our constitutional professor, Adam, who has the greatest deal of, I would say, optimism in the belief that the robe confers upon super, I guess, responsible behavior on chief justices or justices when they enter the Supreme Court. At least that's his hope for soon-to-be Justice Barrett. Adam, you have a tall order to convince.
Well, I think Chief Justice Roberts and his jurisprudence has been quite confusing, but I think there's an explanation for it. On one hand, in Shelby County versus Holder, Justice Roberts voted for a 5-4 majority to invalidate Section 5 of the Voting Rights Act, despite it being reauthorized by a vote of 98-0 by Congress. Yet, in National Federation of Independent Investors versus Sebelius, Roberts was the 5th vote to uphold the Affordable Care Act, despite the fact that there were serious concerns that not only did it violate the Commerce, not only was it consistent with the Commerce Clause, but it was not a tax. And then most recently, in Bostock versus Clayton County, Justice Roberts joined a majority in holding that Title VII includes the term sex in Title VII includes sexual orientation and transgender status. I'm not passing on the merits of those rulings as much as saying it is clearly a leftward shift for Roberts, who only about 15 years ago wrote the majority opinion in McCutcheon versus FEC, invalidating a statute that sought to place limits on individual contributions in campaigns. So his jurisprudence seems to be a bit disjointed. It's conservative sometimes. Now it seems to be more liberal at other times. And I think the explanation is that Justice Roberts is deeply concerned about the court's institutional legitimacy and about inspiring public confidence in its decisions. The problem with that, though, is that if you're concerned about the court's institutional legitimacy, your decisions are not based on law, but they're based on political considerations, and that politicizes the court.
If we don't like I'll tell you why. That can only come from a gentleman that is an originalist, because he doesn't even have a name for Chief Justice Roberts, but there's a reason why Justice Roberts got appointed. And clearly that is because his approach to the Constitution is better than any originalist. But we want to give them a chance. Jeff, why do you think Justice Roberts is running to the left and to the hills?
Well, first of all, I think we have to define what it means to be running to the left. Typically, I think when we think about what a judge is doing and where they're ending up, we're thinking about what the political left or the political right might think of the outcome. And of course, when we think of a judicial conservative or a judicial liberal, I think we're talking about methodology more than results. In the Affordable Care Act case that Adam referred to, for example, Chief Justice Roberts says that the individual mandate on Obamacare is a tax, but he reaches that result through an originalist opinion. Now, I don't personally agree with him, but his methodology is conservative, even though the outcome is liberal. Having said that, I also regretfully agree with Adam's analysis that what Chief Justice Roberts is really all about is the institutional legitimacy of the court. And I think he is, to that extent, reaching political outcomes. I think he's doing the same thing Chief Justice Berger used to do when he knew the die was cast in a particular direction. Sometimes he would flip to the other side to make it a larger majority, to make the court seem more unified than it really is. And that's kind of how I understand Chief Justice Roberts' sort of inconsistent results. Sometimes I think he's flipping to the other side to either write the opinion or assign it and maybe make a narrower opinion than if a true believer wrote it. And sometimes I think maybe he's doing it just to give the court more institutional legitimacy and sort of strike a down the middle pose to be the new Anthony Kennedy, the new guy who kind of, figures out what direction the court's going to go.
Okay. Well, I have a notion first, but first I want to hear from our brain in Miami, young lady. What do you think?
So I just want to take a step back. For me, even us focusing so much on conservative versus liberal creates an issue. It's almost like we anticipate, and we do have to anticipate certain reasoning and decisions that are provided or given by the judges. However, I think we almost stepping outside of the issue and the matter that we would need to focus more. I'm very, very satisfied with the decision that was reached by Justice Roberts, and I see the reasoning there, and it's not the first time when conservative or liberal justice reaches to the other side, and I think it should be celebrated. I think we should kind of try to adjust to that idea and literally try to move a little bit away from those labels and expectations, because really the definition of the justice should not be defined by this one or the other side, which by itself politicizes their existence and their mission.
Okay, Nick.
Yeah, Justice Roberts. I mean, again, the thing is, I think judicial positions should be nonpartisan to begin with. But in my world, one of the famous cases that Justice Roberts decided was the 2010 case called Concrete versus Fromette, which is actually an actuarial case. What happened was the actuaries did not take into account the time value money in a pension benefit, which is like a no-no, because everybody takes into account the time value of money when you're running benefits, because you're projecting in the future and you take advantage of a simple concept. The time value of money, it's worth more today than the future. Well, they didn't do that. And what happens, Justice Roberts, in his very famous case in Concrete, goes, well, even actuaries make mistakes. They're human too. Now, if I work in an actuarial firm, that is absolutely not true. Actuaries are not human and they don't make mistakes. But that's what Justice Roberts said, showing his leaning toward either the left or the right. We're really not sure. But the interesting thing about the opinion in Concrete, and I'm sure you've all read it since you just love pension cases, was that he upheld the fact that, hey, if you don't take into account the time value of money, it's okay. We're going to go ahead and pass the pension and give deference to the actuaries, which they do a lot, by the way, in pension cases. And after reading a lot of pension cases, the reason why is they don't want to get involved in the mud of mathematical computations, so they give deference to the enrolled actuary. So I was very happy and pleased to see that particular case, and that he actually was taking on pension cases at the Supreme Court level, for what it's worth. And I'm sure Professor Adam would just love to talk to his students about pension cases, right?
I'm sure you would. Okay, well, look, I just want to because I think, well, first, it's interesting that he is so dynamic, Adam, only because, first of all, he's a lawyer that wanted to take on math. So that's got to, be significant, because we know that we went to law school because none of us can add, even with a calculator. But I think that the salient feature that we're all missing is that Chief Justice Roberts is from Buffalo, New York. And we all know that is the salt of the earth with a centrist kind of view. And we want to make everybody happy. Although I do happen to agree with both Adam and Jeff that Chief Justice Roberts is trying to look to make sure to ensure the respect for the institution, which is what all middle of the road Americans would like. However, Adam, I guess the question on the table is, do you teach pension cases or don't you teach pension cases?
Supreme Court pension cases.
I don't teach pension cases, but I do teach constitutional interpretation with a particular focus on the 14th Amendment. And speaking of that, one thing I will note about Justice Roberts is that in Obergefell versus Hodges, which invalidated bans on same-sex marriage, Justice Roberts wrote a very spirited dissent, holding that the court didn't have the authority to recognize a fundamental right to same-sex marriage. In Whole Women's Health versus Hellerstedt, he dissented from a ruling holding that a Texas a law requiring abortion providers to get hospital admitting privileges was unconstitutional. So he's reaching these conservative results. And then in June Medical Services, which was just decided last year, he reached the same conclusion about a similar abortion law, but he included a footnote that said this decision is only based on the facts of this case. So I think two things are going on here. I think as a matter of jurisprudence, Justice Roberts really isn't sure where he is right now. And I think that his decisions are very much influenced by his desire to make sure that the court retains its institutional legitimacy. But when you do that, you go down a very dangerous path because that makes your decisions inherently political rather than legal.
Okay, then let me make it more complicated. And that is that we found out today that the nominee, Judge Barrett, it came out, I guess, in disclosures today that she served on the board of this private organization for 3 years and has been a longtime member of this organization, and that this one of their precepts or one of their foundational beliefs is that they do not believe in same-sex relationships. And in fact, they went out of their way to exclude people from the gay, lesbian, bisexual, transgender community, both from teaching as well as enrolling in students, and that she was a prominent person of this for 3 years, which raises the specter once again. Can she separate her private beliefs from her public judicial responsibilities? And what would that mean even if Justice Roberts were attempting to swing back and forth, given, Adam, that you're suggesting that all of these cases emanate from the penumbra, which you believe to be just mere cotton candy made up at the town fair of constitutional rights? But does that impact or change our views of the nominee, Judge Roberts?
No, I'm sorry.
No, Adam, you had your shot. I'm going to go to Jeff. We're going to come back to you, and then we're going to get some sense from Gidry and Nick. Jeff?
Well, I remember being in Colorado at the time Chief Justice Roberts was confirmed following his nomination to the court. And I was, as fate would have it, in a constitutional law class on separation of powers with Justice Scalia, and he announced it to everyone in the room, and of course everybody clapped. And I went to him on a break and said, does it bother you at all that Justice Roberts said in the hearings that he believes in substantive due process, that he said, well, judicial decisions of the Supreme Court tell me that there is a privacy right, that there are rights emanating from substantive due process. And Justice Scalia's remark was, nothing really bothers me anymore. But I guess maybe when you're 85 or whatever, you can say things like that. But anyway, I remember back then thinking Justice Roberts isn't going to be quite as down the line originalist as we may have thought. And I remember it was those comments that convinced Senator Pat Leahy to vote to confirm. So, I don't know that I think there were clues in his methodology, even back when being confirmed.
Does that really matter right now, given that it could be true that we could be witnessing that Judge Barrett, the current nominee, hid what could be some very troubling notions, deep-seated notions that would affect rights conferred to whether abortion or same-sex marriage or any of those issues, and the right to privacy? I mean, could we be witnessing that? I mean, that she's so stalwart and that we didn't have a chance to question her on those issues, Jeff?
Well, I'm not concerned that she served on the boards or whatever. I mean, Chief Justice Ginsburg, for example, before she was appointed, was counsel for the ACLU. She had staked out positions on a lot of issues. I don't think we want nominees that sort of have never thought about what they think about this or that issue. The question is, can they put on the robe and put that aside? Now, with respect to Judge Barrett, I would be more concerned about the fact that she didn't disclose it, if in fact she was asked to, than the fact that she's got that she has had opinions on something as a political matter.
All right. Well, we're going to move on. I got you next. But listen, Jeff, I just do have to drop this footnote, which in legal, for our audience, for lawyers, a footnote is kind of like, yeah, I think you're wrong, but I'm not going to make a big deal out of it. But I do want to just make sure I'm on the that I think you're wrong. Nevertheless, so that's a footnote explained. The ACLU actually is an organization dedicated to upholding our Bill of Rights, which all of us really care about. So I would rather have somebody defend the ACLU because those are our first 10 and then later 20 amendments that say that we can be free. Now, Girder, what do you think about these two issues? Is Judge Barrett, one, did she withhold? Two, should we have had a chance to exercise it? Three, will she make Chief Justice Roberts, completely irrelevant because of her positions? What do you think?
Very good questions. And actually, I think a lot of different things. As I mentioned before, I am scared. I don't feel very comfortable having judge or future judge to say Judge Barrett take the post of such an important position. I do think that it is problematic with her having an ability to cement the conservative vote on the Supreme Court. And I think it is being kind of vocalized and understood by the population, by the public, but also by the justices themselves. So as I'm not an originalist, I see the Constitution and the Supreme Court as living organisms. And I do think that combination of different people with different kind of stance and different opinions is not such a perfect history as Jeff has mentioned. I think it makes them also to change and restructure, and therefore I still believe in justice, and I think that they will work together, and I believe that there could be some surprises. Hopefully this recent indication in the Pennsylvania decision with Supreme Court justices will indicate that in the future we could reach some fair and just consequences.
Okay, Nick, the table is set for you. It's a tall order here, Nick. Where are you going to start, buddy?
Well, not really, because the thing is, see, you guys are all interested in the excitement of, the Roe versus Wade and all these emotional 5-4 decisions, where I'm sitting then looking at the nuts and bolts of what makes a difference, such as the very famous case Clark versus Raymaker, which nobody wants to read. Well, maybe you did read it, Kedri, but let me tell you about Clark, and it impacts everybody, as opposed to Roe versus Wade and some of the stuff that you've been bantering around.
Which is just mere dust on the road, right?
Yeah, right. Let's just forget that. Okay, Clark was a very important case because it dealt with inherited IRAs. Okay, in this particular case, what happened is Raymaker was actually going to inherit $300,000, but they were bankrupt. And the real question before the court was, because your IRA is protected from creditors in bankruptcy, if you inherit, is it still protected from creditors in bankruptcy? Now, notice that affects a lot of people over the next 10 or 20 years are going to inherit IRAs, especially my 1%ers. Bill. Okay. And the thing is, if they inherit the IRA and they're having financial difficulties, like a lot of people that are suffering through COVID-19, they inherit it, they could lose it all. That's a big deal. And the reason the Supreme Court had to listen to it, there was a conflict in the circuit. One circuit says, toast, you lose it. The other circuit said, no, you get to keep it because it's an exempt asset under the law, as most retirement plans are. Mm-hmm. So the Supreme Court listened to the arguments, and in a 9-0 decision, they held. 1 minute, we got a commercial break. Just they held. They lost the entire IRA. 300,000 vaporized. The people are busted, broke, bankrupt, and the 300,000 went to the bankruptcy court. It was a big case, and big Supreme Court case, and I know that, hey, look at an exciting like Roe versus Wade or whatever they're talking about, in social justice, but it means something to everybody. The IRA inherited, you could lose it. So it created this whole cottage industry called IRA trust. And so what attorneys do when somebody has an IRA, you set it up in a trust using state spendthrift law. So what happens is that the money goes upon basically is in an IRA trust. So when you die, the assets are still protected from creditors. That whole cottage industry still exists today, called IRA trust. It helps everybody out to know about this issue, but and that was before the Supreme Court case, and I'm sure that Adam's going to make sure all his students know about Clark versus Raymaker, and they can draft IRA trust.
Well, Nick, listen, I certainly have to agree with you that I think that
it makes a difference. The Supreme Court makes a difference.
I know.
There's no partisan stuff in this. There's nothing partisan about that. It's about the money.
I will agree with the Supreme Court makes a difference. I think we all will agree on
Thank you. And Clark versus Raymaker needs to get some love as opposed to Roe versus Wade.
Okay, well, I was going to suggest, one, you hold your bullets for Google. Two, you're never going to get love from Adam because in his rarefied air of constitutional social justice, gobbledygook speak, it is not sexy enough. So he doesn't care about pensions, even though it's going to affect every single one of his students. However, someone will be after. Oh. Adam, you're protesting? What do you have, Adam?
Oh, sure. I absolutely care about that case. I also care about, but I care more about the methodology that the court used to get there. And if you want to talk about a case of impact, Clinton versus New York from 1996 is one of the worst decisions ever when the Supreme Court by a 6-3 margin invalidated the line item veto. What are they doing interfering with the coordinate branches? They both passed it on a bipartisan basis. Congress signed it, and the presentment clause was ambiguous. So why are they getting involved when reasonably alternative interpretations are possible? They should just stay out of it. Leave us alone and let us make us more democratic.
Yeah. I mean, I can't help this, but we're coming back to Clinton. I mean, Can you please put us all straight on Adam's pet peeve, which is Clinton versus
New York? Yeah,
right. The line item veto, please.
Well, look, I think you can make an argument that back at the time of the founding, and you could make an originalist argument that bills were a lot shorter, that they weren't, dressed up with all of these riders and other things that were never meant to be in the bill, just to get it through, and that the president, can veto pieces of a bill and not the whole thing. The problem with that is it's never been done. And so it's a significant transfer of power from the legislative branch to the executive branch to let the president sort of amend by vetoing pieces of a bill. I think it takes a constitutional amendment to get there, not a legislative act. I don't think we can allow Congress to delegate particular legislative powers like that. So that's my take on it. I think the court was perfectly within its rights to get involved and say where the line between the two branches are. I guess what that shows, though, is two originalists can have fun too, because it's
absolutely.
Yeah, I guess it's a block party. And here's what you have to say. They're not presenting themselves as a party.
Well, the thing is, if it was a 3-panel bench, when I go before the Ninth Circuit, usually you get a 3-panel bench. So you have two opposing sides. You need the tiebreaker. So you throw Guidry in, and you get to be the tiebreaker here on Clinton versus New York. Not that we would put you on the spot.
No,
we will.
Oh, never. Well, I will agree with Jeff. I really do think that. I think that there are a lot of issues that could be discussed when it comes to that, and I do value both of their opinions, and I think that there's definitely is the meat in both sides, and
Okay, well, Nick, I guess we stand corrected. No, you can't. No, yeah, that's right. Jeff is in the winner's circle.
Well, yeah. Well, this is the 3-panel court up above. We're just commentary. That's it.
Hey, Nick, welcome to the bottom feeders.
I've been there.
Just letting you know. Okay, so I guess I do want to ask this, and I will start with our resident expert on this, which is an expert on top of an expert, and that is this issue of whether or not illegal immigrants should be allowed. Because currently, as you know, the Trump administration is arguing that in front of the Supreme Court that illegal immigrants or illegal aliens should not have such representation. What do you think, Deirdre?
What do I think? Well, I absolutely think that the representation is needed. So there is a program. 14 months ago, there was a program enacted by the order of the Trump administration called Migrant Protection MPP program. And one of the cases that right now was picked up by the Supreme Court is the case that was filed by Bill, your favorite organization, ACLU, against the Trump's administration. And the core argument for this case is saying that this MPP program that was enacted by this administration imposes extreme and harsh circumstances and for the people who are being sent back to Mexico to wait there while their asylum cases are being pending. And right now there are at least 60,000 asylum seekers, refugees from the Triangle countries, from Cuba, who have been strangled, trapped in the middle of Mexico in the border between United States and Mexico. We're talking about Matamoros, Juarez, Laredo, very, very dangerous areas. And they are being there for 1 year for hearings. And the damage, the harm that is being, that those people are being set in, it's absolutely unprecedented. And based on the ACLU argument, such conduct is against regulations of the United States and also international law. Whereas the Trump administration is saying that this program has been very successful, that they were successful in maintaining at least 60,000 asylum applicants outside the United States instead of keeping them inside of the United States, releasing them to their families or keeping in the detention centers. However, this argument really, really skips the all underlying issues with this particular problem. Really quickly, this MPP program was enacted based on the agreement between the United States and Mexico. And one of the requirements for this program to be operated was for Mexico to be able to provide necessary safeguards to those refugees. It's not being done.
Wow. So, who wants to take a shot at unpacking all of that? I can't even muster up the.
I'll take a shot at that. And so here's the problem I have, Guidry. I don't know if you ever saw there. It's not in Miami, but go to New York. You have the Statue of Liberty. It says, "Give me your poor, your tired, and your huddled masses." Okay, that is a complete fabrication and lie. Let's just get real. We need to do something about that Statue of Liberty because we don't want the poor, we don't want the tired, we don't want the huddled masses under the Trump administration. Okay, so the thing is, it's just got to change. So when you have statements like that totally misrepresent the policy and the position of the United States of America, then this is the problem, because the immigrants go, hey, your Statue of Liberty says, give me your poor, your tired, your huddled masses. I'm one of them. And the first thing you do is say, no, you don't understand. We don't want you. And the Statue of Liberty is just a complete fraud. It's fake news. And then immigration attorneys like yourself, which I'm not one of, have to fight a system which I don't even know how you win that over there. Now, when I was in Miami, we had Cubans literally wash ashore. When I worked at the city attorney's office in Miami Beach, we got to figure out what to do with them. But they were given asylum because it was a dangerous place back then. In Mexico, which they're mainly from Guatemala and all these other places, they're getting hammered by our policy. I mean, it's just that our immigration laws actually suck. They're inconsistent with what we're saying in the Statue of Liberty. I think what happened is we need to take that sign down, take that statute down.
No.
You know,
No.
well, they did that here, Bill. All the Confederate statutes, I don't know if you know this, Bill, got torn down.
Yeah,
they tore them down.
Well,
Okay, well, you got to add one more, the Statue of Liberty.
All right, no, Nick. Look, those statutes got taken down because of my buddies over at the 99. You know, so that's why those statutes went. We're keeping this one, but I'm going to ask Adam.
Why? It's a fraud. It's a fraud, Bill.
No, actually, first of all, it looks very, very nice on my mantle, harbor of New York. So I don't want to take it down for that reason, and I happen to have my own here. But nevertheless, Adam, the fundamental question is: listen, does someone coming here under the auspices of you're tired, you're poor, you're huddled masses, those seeking freedom, do they have a right when they get here to at least being represented? How would you come up with a decision on that? And I'm hopeful that the liberal part of you will be purpose driven to at least a result on this one. Adam,
I'm an originalist with a heart, and or as they would say, a compassionate conservative. Yes, I think they have a right to representation, but I think the broader problem is this, and here's the solution that I would implement, which will probably upset people on both sides of the aisle. For the people who are here, undocumented immigrants who have not been convicted of a violent felony, give them a path to citizenship and stop engaging in, that's it. Give them a path to citizenship while simultaneously securing the border, and 3, increasing the number of judges at the border that can expeditiously adjudicate asylum cases.
Okay. Jeff? Yeah, Jeff.
Can you hear me all right?
Yeah.
Okay. I'll agree with most of what Adam said. The caveat is I would give a path to citizenship for the dreamers, for the people who were brought here by no fault of their own, by their parents when they were 4 years old or whatever. I also agree with more judges at the border and quicker adjudications, and I think that requires a legislative fix. I think the idea that we're just going to let them in and figure it out later is sort of like the Queen of Hearts in Alice in Wonderland. Trial first, verdict later. Or verdict first, trial.
I know, we got you. Well, you see, there you go. Gilbert, it's back to you, because this is a very, very rare moment. And what we have is both Jeff and Adam agreeing on the results, getting there creatively under their school of thought, keeping it all together. You've got Nick nodding his head, and I'm up to you. So please get on your soapbox and bring this one home for us. What are we going to be doing about, or what should the Supreme Court be doing about all 3 of these cases? This illegal funding of the border wall, this throwing legitimate asylum seekers into these dangerous zones down in Mexico, and not even giving them a lawyer when they reach our shores. Deirdre?
Okay. So thank you, Bill. So my answer to all 3 of them will be no. But there are not to do that, to stop it, to come up with a better solution. There are a few points that I want to mention. First, Nick, people who are coming because of that Statue of Liberty are really not because they are tired and poor and looking for a better world, to look at that Statue of Liberty. Most of them, and asylum is based on them, people are coming who are really fleeing their countries. And I know with the global changes right now in the world, we have a lot of numbers of people coming, and we will having exponentially larger numbers in the future. Therefore, I am all for the better system to process those people. Right now, the bill for the people who are being detained, who have to wait for their hearings for extremely long times, that could last even for over a year. People also coming to those courts, multiple courts from Mexico, just to process to the United States to give an application for asylum, come another day because they did not get an interpreter or different documents translated. The bill that is covered for all these services is literally by taxpayers, and it's a very, very large bill. I will not even go to the numbers for how much we pay for people who are waiting for their asylum or immigration proceedings and being detained in the detention centers by ICE, how much money we pay for that. But that's off the topic. So my point is that it seems like this immigration system that is structured by this administration and actually even worsened is because of really making money. Certain institutions, privately owned detention centers, courts also are not being fully used. It doesn't matter. As Adam said, okay, we need to have more just judges to handle those cases and be quicker at processing them. But if we don't have a training or an agreement, mutual agreement between ICE, between the government, and also certain NGOs who represent those rights, if we don't have this agreement, we're not going to get really to the point as quickly as we want to get, or as efficiently as we want to get. And in the midst of all of this noise, I think a lot of is being lost, such as there really are abilities to process those immigrants. There are really necessity for immigrants in the United States. United States depends on them. And I think as originalists, you also should support it and understand that, let's not forget the United States, and not long time ago, how we were really put together into this, beautiful place right now to discuss. So really quickly, because I know I'm all over the place and I could talk about it for hours. I just want to say that I really do think that there is a process to process the immigrants. There are not that many. Going to MPP program, for instance, less than 60, right now it's going to be less than 60,000 people because some of them already had the hearings. So to process them to the families, also there is ICE. ICE institution is very, very well operated in the United States. As Adam said, people who have criminal records, certain different violations can be picked up very easily. Those people will not be, it's difficult to escape ICE. ICE is everywhere. So we can really control and manage this issue in a more humane way, in a more efficient way, in a more productive way, where both sides, United States and also the immigrants, would benefit. And I think it's important at this point of time, particularly with this administration.
See, exactly. That is what we call a lawyer. Lucid, reasonable. And she convinced the crazy wings over there up in the upper corner here that we're like, and she pointed out to you, Nick, you judgmental 1%er, the immigrants are not poor.
No, they're worse than poor. These people, apparently, these people are escaping prosecution.
No, I'm about to serve you up a juicy one right now.
Yeah,
we have handled that issue, and hopefully, everybody in our audience will catch up to the lucid opinion and wise thoughts that we have here. But Nick, your favorite subject,
which is
Google, YouTube, and the oppressive. Okay, go right ahead, Nick. You can start us off. That's right. You're the only one who's read it.
64 bloody pages. I had to read it. It was like must-read TV. It's the United States versus Google, and joined in by the state of Florida, where you're at, Guidry. The state of Georgia joined in, where Professor Adam is in. State of Indiana, Commonwealth of Kentucky, state of Louisiana. They all jumped in on this case going after Google. So what did Google do that was wrong? All right, here's one of the problems. Okay, they control the search engine, but that's not a big deal. How they control the search engine? They made an arrangement with, this is the big thing I got it. They made an arrangement with Apple. You probably heard of Apple. Apple's a big company. They make these things called cell phones. And what happens is that the deal was this: the only search engine you can have on here, absent a lot of work, is Google. In your in your Apple phone. And what they did is, to make this deal go through, they give what they call a revenue share to Apple of 8 to 12 billion a year, not million, billion a year. They call it a revenue share. By the way, revenue share is a nice word for kickback, by the way. Okay, I mean,
wait, don't you mean
it's a kickback? It's a kickback, no matter how you look at it. They didn't say that in this document, but look, being in financial services for 37 years, I've coached all my people. You talk about revenue share, don't talk about kickback. But
okay, Nick, having represented my friends in the financial institution, they call it a VIG. Okay, so
Okay, so anyway, there's a kickback. I'm just doing what they didn't call it. The lawyers on the Department of Justice were really nice. They said it was a revenue share because that's what Google called it. In reality, it's a kickback. What they did is they said this: Apple, we're going to be only a provider, and so what they did is they controlled 95% of all the searches that go through your cell phone. And they did it with Android also as well. And they did it with a lot of places so that the only place that if you want searches to take through, it'll be through Google. And so now what we're going to see is, of course, we just see the complaint. I like to see the answer. You got to see the other side. There's always two sides to every story. But if you read this complaint, what you do is you say, they even say that the Google of old that was invented in a garage somewhere in California has changed. It's a monopolistic cow that goes out and destroys competition by using basically kickbacks everywhere they go. I mean, excuse me, revenue share. Right. Everywhere they go, so that they have effectively destroyed competition. And there are some good search engines out there. One was DuckDuckGo or something like that. I've never heard of it. And what they do is they make sure that your searches are protected, but they can get no space. They get no traction, Bill, because they can't get past these huge amounts of bribes, revenue share, kickbacks that Google does in the term of 8 to 12 billion a year just for Apple alone.
Now, Nick, I mean, that kind of sounds like that's stuff straight out of the dark web to me.
No, it's right here in this case. But also, the thing is, look at it this way. Apple and Google are in little cahoots to make sure this takes place. Apple's not innocent, and so the thing is, and Apple, as we well know, is in litigation here by basically monopolizing their little app store. Mm-hmm. And so Epic and getting a 30% commission, revenue share, kickback from everybody that puts the app on Apple. Okay. Right. And now the thing is, if you say anything bad, like we just did, you know what they did? They throw you off. In other words, they basically say, okay, so if Guidry complains, good. You'll never have a search engine again on any of your computers. Now, you tell me that isn't a big monopoly.
Okay. Well, Nick, we are about to tell you because I have a question. And this is how I'm going to go. We're going to go to Adam because he was the odd man out the other day, and I was almost with him before I regained my senses. And then we're going to go to Jeff, and we're going to come back around to you, Guidry, and that is this, Adam. I was with you there for a while with, why break them up when they're not doing any harm? I mean, look, sometimes you can accept a monopoly, and I believe that was a position that you had. However, today it came across the wires that there is a constitutional law professor up at Fordham University named Zephyr Teachout, who wrote a book that said big ag, big tech, big whatever, busts them all up. And her argument, in her school of thought, regardless of how you interpret the Constitution, is that they all need to be broken up for significant reasons. She was quite passionate about it, and I want, just to be clear, she's coming from the progressive wing of the Democratic Party, and stands in I guess shoulder to shoulder with Bill Barr. Now, if she is representing the progressive wing, or in your case, the liberal wing of your ideas over there, and she gets that, how can you still maintain the position that these companies should not be broken up, busted up, and sold off like little pieces of fish at a sushi bar? Adam?
Well, first of all, I don't know how they would break them up, and the logistics of that would be so complex that it probably would be a nightmare. Number two, I don't know that you can establish that Google is acting with an anti-competitive intent. What does that mean? Like I said yesterday, the very nature of a business is to destroy its competition. So how can you draw the line and create a workable standard that distinguishes between what's permissible and what's not? And the third thing is, sometimes monopolies are okay. I mean, studies show that people are happier with less choices. And in some contexts, that may be okay. So look at the empirical research that says that, and it makes you think a little bit differently.
Jeff, right on cue. Oh, my God, Adam, thank you for that high fastball. I want you guys to know, from a former pitcher, college athlete scholarship. Jeff.
Well, first of all, just to digress to the Clark case, Nick, the definition in the dictionary of an actuary, I believe, is an accountant without the personality. when it comes to Google, yeah, I'm a Jeffersonian. I believe I am suspicious of concentrations of power, public and private. And when we're talking about tech, tech is running the world right now. It is the way everybody's doing everything, and so I think having that in the hands of a very small number of people is a dangerous thing, particularly if they're engaged in anti-competitive conduct. And I think the way you determine that is there are things companies do. They make a better product, or they figure out how to make a better product for a cheaper price and still make money. And nobody's saying you can't go out there and grab market share by doing that. It's when you make a deal to grab market share, to grab 85% or something, so you can jack the price sky high. I guess in this case it was 95%, according to the statistic Nick quoted. When you're combining with other companies to grab that much market share and squeeze out the competition, that's where I think you've got anti-competitive conduct. And in this case, I think there's good evidence. It seems to be good evidence that Google has gone around and made deals with everybody to exclude all of the other search engines, and I think that's where they're going to get in trouble.
Okay, and Gary, I'm going to come up to you just after this because I've been quiet on this issue, but I've been simmering all day. And Adam, I owe you an explanation for leaving your dugout, and that is simply this: that Google it concerns me how they use their authority, and when they attacked the defenseless IBM TV network when we were simply engaging in free speech and threatened to cut off that free speech, it was unfair because it interferes not only with an ongoing business, and we have laws for that. For example, under tort law, we have tortious interference with third-party mutually beneficial relationships. We have all kinds of rules that limit what people can and cannot do. And yet Google, through its subsidiary, that Leviathan that is YouTube, unnecessarily attacked individuals, and in this case, a network attempting to stifle what it is that we are trying to do. That was unfair, unjust, unnecessary, unprovoked, and I now say, I dare say, I hope the Supreme Court will say illegal, so bust them up. Now, Deirdre, please.
Bill, thank you. The microphone is on the ground right now. But I will agree with Adam. I will agree with Adam that sometimes monopoly is okay. And you know when the monopoly is okay? When it is not too big. And here right now in this discussion that we are having, there is 800-pound gorilla somewhere in the corner, which is the future. What is going to happen to this reality if we're not going to do anything? So right now, Google and Apple, two incredibly strong, two of the biggest companies in the world, not in the United States, right now have unprecedentedly high, big market share. They also have very deep pockets and incredible connections and influence. That definitely creates an urgency for this issue for this reality to be dismantled. And I agree with Adam once more that it's going to be difficult. However, it has to be done. It definitely has to be done. I agree with everything that was said prior, and we have to do it.
Listen, I understand that you're a skeptic, and I appreciate that because it's all, how is always a legitimate question. And it just so happens that we're in that season here in the United States, our holiday season. And if Dr. Fauci will allow us to celebrate it, I know Nick has a solution about how we were going to carve them up. Nick, which piece would you cut off first of Google?
Oh, it's by the way, it's really simple. Okay, remember I told you they dominate 90 to 95% of Apple and Androids by kicking back 8 to 12 billion a year. Now the thing is, can you imagine this? If I said, I'm going to go to the Supreme Court and I say, look, for every decision, I'll kick back you money. We'll do a revenue share. What would the lawyers say? That's illegal. You can't do a revenue share with a judge. Okay, well, listen, that's what they're doing with Apple. They're playing footsies big time, 8 to 12 billion a year. The solution is really simple. There's a great search engine called DuckDuckGo. You never hear of it, but these guys developed a search engine that has built-in cybersecurity much better than Google. but they have nowhere to place their product because Google locks down Apple between 8 to 12 billion a year. I would bust them and say on the search engines on your mobile phone, you have to use another provider. In other words, in other words, it's a punishment for the crime. You're kicking back 8 to 12 billion a year. Go use DuckDuckGo. It's a better search engine anyway. And let the little guy have a chance to play, because right now that's not what they're doing. What they're doing is they're crushing the competition.
No, Nick. No,
Competition.
I just want to see where your line is, because I think I know where my line is, because I'm pretty heated on this one. Would you go so far as reparations for the American consumer and make them give some of that $18 billion back to the hardworking guy who has no choice but to buy?
Well, the thing is, this goes back to this goes back to the tax issue, which is beyond the scope of our argument here, counselor, in that Google and Apple both have their search engines and their intellectual property stashed offshore using what they call, and everybody in the tax, when Beckett was here, we all know it, the double Dutch Irish sandwich. Go Google that one. And look at Professor Seinbold at University of Southern California. He was a practicing high-level tax attorney doing high-level tax work, such as the boss, son of boss shelters. Everybody knows about those shelters, and the double Dutch Irish sandwich. Then he came out and said, look, do you guys know that these big tech companies are stashing their money offshore using the double Dutch? So they're not paying corporate taxes. So yeah, you know, what they need to do is they need to take a shot at the bow and really look at what these tech companies are actually doing. And this, we don't do any evil. Remember, that was the Google.
No, I got you. Oh, thank you. Thank God, you know, I have my mask here, and we all have our PPEs called the computer Zoom network, because that's almost unhealthy.
Well, they're listening to us. I don't know if you guys know this. Everybody on IBM TV, YouTube is examining everything that we're doing right now on IBM TV.
Yes, we are.
So everything that I'm saying is being reviewed by YouTube and IBM.
I know. Nick, and I just wanted to make the point that, with my point earlier, that we at IBM TV are not going to be, intimidated. One, and we've got more lawyers than they do, because we have an entire panel of lawyers. But what I do want to do, I want to quickly go back to Adam and then Jeff for your perspectives on this issue, because clearly Nick and I have already decided what our vote is going to be, and I believe we have an indication from our justice from Miami. Gentlemen, Adam and then Jeff, please.
Well, I'm not an antitrust expert, but I kind of feel like Google is like the Martha Stewart of antitrust law. I mean, you have Amazon, right? You have Barnes and Noble. How does any small bookstore even attempt to compete with them? In other words, you have situations like this all over the place, and I just think that breaking up Google is going to be a nightmare. And more theoretically, I don't know. Sometimes I like less choices. I think it makes people happier when they don't have to choose between so many different options. So I'm not so upset by.
Okay. All right. Now, Jeff, this is where I really need you to hit a home run for the team, because that libertarian streak in you, I know, as out of the Goldwater mold, Adam is saying less choices. How does that stick with you in Utah, Jeff?
Well, I've been saying on this program and before for several years that I thought we needed another Teddy Roosevelt, that we have had. Like why Bill Clinton ever allowed that ExxonMobil merger to occur, and everybody wondered why gas went to $4 a gallon. Well, think about it. I think in this situation, the big tech companies can be particularly dangerous, like I said, because everybody does everything through tech. And even what political messages people get come through Google. And so I think it'd be a healthy thing to have a larger number of people competing for eyeballs when it comes to the internet. I also believe that it's one thing if Google just makes the best product at the best price and grabs market share doing that. Nobody's saying that you can't do that in American business, that it's illegal to get too big. But it's illegal to get too big through anti-competitive conduct, and the agreements the exclusionary agreements and cash incentives that Nick described that Google is giving to the major players in the cell phone industry, for example,
Okay.
have frozen out all the competition, and so
Okay.
beginning there,
Okay.
I think bust them up.
Okay, there we have it. Now, listen, all other questions or appeals will have to wait until tomorrow. Chief Justice Nick, can you bring us home and land this plane for the day?
Yeah, it's 8 o'clock, so we have to go. So we do want to thank our panelists for coming and our viewers for watching IBM TV. And we'll be on tomorrow, and then Friday we're not on. So I think tomorrow's our last day. But I think we actually go ahead of the election, don't we, Bill?
Yes, we do.
Okay, so we're going to be right before the election. And so I'd like to thank everybody and our panelists from watching IBM TV and the people around the world. Let you know what's going on in the lawyer's den.
No, wait. Point
What?
of personal privilege. May I?
Yeah, we're past
tomorrow
that.
we may have a panel or a distinguished gentleman coming in from around the world. So we may have international lawyers. So
Yes.
please look out for that. Tune in and we'll see how it pans out. Nick?
Okay, right. Yep, we'll see you tomorrow. Bye-bye.
All right.